Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Hey, good morning. Good morning. Good morning. Good morning. Good morning. Oh, sunny day. Good morning, love. We are going to hop into the Karen Reed. I know I'm late behind the ball, but last night I had the best sleep I think I've had in a year. And I had no intentions of breaking that fabulous sleep at all. So we're going to go into the Karen Reed, and then we have another trial today that we're going to also be going into. But right now, this is where we're going to start. And I may put it on a little faster speed depending on how fast or slow they're speaking this morning. So let's get let's get in there. We're going to skip through all the pleasantries. As usual, the same courtroom. Here we go, y'all. And because I'm on playback, I can put this on.
117, the Commonwealth versus Karen Reed. Can I have
Why are we glitching? Why are we glitching already?
Good morning, Your Honor. Hank Brennan for...
That's her. That's on them.
Good morning, Mr. Jackson.
Good morning, Mr. Jackson. Please don't tell me this is
that
the way this is going to be this whole live.
End of the hearing today. We've also got Mr. Burgess here on Ms. Ross's opposition to the notes. And then there's the Commonwealth's motion for
Hello, it's
reciprocal
Britt.
discovery
I actually got
pertaining to
good
the
sleep. I've been
employees
fighting
of
off
ARCA.
whatever everybody's had.
And the last one is
And I'll
that
stop this. Oh, I got to get back up here. I have been fighting off what everybody's had. I've been feeling really run down, achy, sneezing a lot, just not feeling my best. And last night I had the best sleep I've had in like ever. And yes, I slept in.
Depends upon her having the ability to use the tools of the journalism trade. And among them is the opportunity
What?
to
Let's
reliably
back this up because I don't know who he is.
today.
Who is that guy?
We've also got Mr. Burgess here on Ms. Ross's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Bertie.
Good morning, Your Honor. Rob Burchie for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit the
Sure.
court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes, and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has
You are unmuted.
particular reason to delve into them.
Good
So the
morning,
question before the court
Toxic. Good
is whether
morning,
the Commonwealth
Tash.
should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality
Okay,
with the source
Tash.
in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in the prosecution of the defendants. The stakes for Gretchen Voss are considerable, as she set out in her second affidavit submitted to the court with our motion for reconsideration. Her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade, and among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes. And that is what renders a journalist's promise of confidentiality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with a source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On
It's
page 2 of our
low,
motion
but
for
I'm gaining it.
reconsideration,
Give me a
quote
minute.
From Primer on Journalism, that says off-the-record interviews, quote, are essential
Is that
to
better?
building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it's a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, oh, that was a case like this one, where that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out from the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews when it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings. It did not treat this confidentiality promise as a factor in the equation. That we submitted was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, note it says materials, not source identities, and courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests will impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compared to that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tape. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information has extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information, and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtakes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. There will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The Fourth Estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism.
Are we done?
This is the most expensive kind of journalism.
Testing,
Reporting, writing,
testing,
editing,
testing. 1,
fact-checking
2.
investigative pieces takes significant time.
Testing, testing. Why don't I hear
Magazines like
myself?
Boston Magazine will not be able to risk becoming enmeshed in
Testing. There we
situations
go.
such as this one, with results
Sorry,
that shy
guys.
away from controversial topics, and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet if it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interview notes in this case risks putting her again in the limelight Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that that shows that she was dedicated to covering the trial, come what may. She tells me she has, in the recent past, gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right, thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Birch. In the amicus brief, or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Well, there's nothing in the interview notes that is reflected in the story except architectural details, that there was a rosary on the bureau and the wall was blue, or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a report for this, other than the fact that she's a reporter and she's done the investigative work already, that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Kamala?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right, so I'll take this under advisement. Thank you. All right, so paper 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ACA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Kennedy's recitation of our conversation this morning. If it pleases the court, we did get that TUI letter. I was copied in on that letter late last night. Reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we could have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was thinking.
So we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right. So this brings us to the Commonwealth's motion.
Sorry, guys, I had to
Defense
create a
witness Richard
thumbnail.
Green's
Hello,
debunked opinions.
Angela. Hello, love.
So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was
Haley
a
Mouth. Today's the drawing.
affidavit attached, a report attached from Mr. Whiffen. The
Today is the drawing, y'all.
defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
I'm going to speed this up.
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry.
Hold on, guys. I have a little glitch. I don't know what the hell is happening to my computer. Exit full screen. Thank you. There we go. For some reason, it got stuck and I couldn't move it. You didn't miss anything. I paused it. We're good to go.
Is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations, and surmise, and conjecture, and claims that have no factual basis. But there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data, but we don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common viewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case. Mr. Green is going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is
I'm
that of an expert
missing
that can
a
but it takes
charging
an expert
device.
to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools, because he has a number of x-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites 2 opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite, he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engaged in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense house, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks
Gotta
about
charge my
different
computer
programs
keyboard or I'm
because
not
he
gonna
wants to
have
view data.
one.
That gets back to the X-ray analogy. He is viewing data from many different programs to say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he
Yes, y'all go to As the Gavel Drops
Page
for
7
all
of
of your
number 14.
needs for
and he says
court documents.
that the Axiom user manual describing the artifact as follows: that the artifact is in Safari suspended state tabs, and then has the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual. We don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell really for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time, and if that tab is reused, the original time will imprint. And so certainly Mr. Glean knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them or makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 227. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, the wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit. number 16. Look at this phone that there were two. Surprised that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number one, doesn't have any resonance. Anything somewhere, somehow. Not an uncommon. The claim, or the opinion number two, the defense would like the jury to hear, is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number two, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. An extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number one are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when we don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact in data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it happened, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do, they match.
Hi, thank y'all for joining me
Claims that he did not
today.
receive
Don't
the
forget to put
PDF
the I liked and
when
do
he
all the
received
below on
download.
the
And because
ticker
there
in
was
order to
a
be
dozen
in the
different
drawing.
times, he then
It happens
sprints out to a
today.
different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. Most expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So has
I'm going to get me a cup of coffee. I'll be right back.
the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffen's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There's no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known or potential rate of error. Well, if we see and read Ms. Hyde, and it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, positions of Mr. Green are not only unsupported, they're unverified. And so what arises from the subterfuge is that Mr. Green is really just a vessel, or an attempted vessel for the defense, third-party culprit defense. It is not lost on me, I'm not unmindful of the date on the phone being a Sir Talon Diane call that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive the hold. Under the extraordinary broadness of circumstances and the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance, that there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. Mr. Green is going to be witness in front of the jury, like in the fact that he has no methodology and he's wrong on the science. In addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a Lanigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Leslie?
May it please the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search house long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of this whole testimony and opinions. I have provided Your Honor with 2 exhibits, demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor.
Hi. Hey,
Brennan
Haley
challenged
Mouse, out and about with
methodology.
Diane.
None
Talk to
of
cool
his witnesses,
sunny day.
neither Mr. Whiffen nor Ms. Hyde challenged the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now.
Preach it.
Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Cellebrite UFED, a tool of Cellebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data. We immediately processed it the proper way and put a hash signature so that there could be no contest. What the Commonwealth fails to tell the court, Your Honor, is
I don't know what happened, y'all.
and
That's
that
on them.
leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking
Why are you doing this to me this morning? Why are you doing this to me?
of the original hash value, which is not possible with great key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffin saying, I can't
Mr.
validate
Whiffin.
this hash value because of the way Trooper Garino processed it.
I'm
Do it,
sorry,
Mr.
love.
Trooper Garino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Garino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Garino only provides a PDF of the hash value. He used Gray Key, which was a mistake, because Gray Key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction.
Raw
Finally,
data.
after
Raw.
the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person. And the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffin concedes it on page 3 of his report.
Ooh,
starts-
snap.
And I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Garino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1.
Ooh, you
So,
preach it. Preach it.
Importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffin, Ms. Hyde, and Mr. B all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Cellebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5, and 1 through 4 is usually all one needs to do as a data forensic examiner, but Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it could be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffin who provided the most lengthy report in this motion Mr. Whiffen only used 2 forensic tools. He only used Celebrite Physical Analyzer and his own software, Ardex. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used and how insufficient Mr. Whiffen and Mr. Garino are. So if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert-Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, and this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 2/27/40, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, Those witnesses diverted at the end as to whether what that timestamp showed, 2:27:40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Green in terms of his training and certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lau. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I'm not here today to challenge Mr. Whiffen's qualifications, but how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used, because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to, yeah. So
I'm happy to look at the report if that's what you're referencing.
I'm
but Where
going
do
to
I
go to the
find it?
report next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde.
Yes.
Thank you. So and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Celebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to 1 physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite, to Axiom, to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23/2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the house long to die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees it's an opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now. It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite Physical Analyzer, and it's gone. The search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Cellebrite Physical Analyzer? We don't know the answer. All that is stated is a bold conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And this, though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely house long to die in coal. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Cellebrite just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 22740 AM ET timestamp, the determination in prior analyses and from Cellebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis, and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Cellebrite Physical Analyzer.
So are you telling me that we should have a hearing?
There's
No,
no need to have a hearing, and here's why.
no.
There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? If everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? It's because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology.
Whoa.
So what is it that caused
dude.
Mr.
Take a breath. Take a breath. Woo. Y'all, you better get your likes in, subs in, memberships in today because the drawing's today. Oh my gosh. Is he? Oh, and look what came in, my Girl Scout. Now, I'm very frugal and I do not share. Do you know those people that go, oh, shh. That's not me. But this is spicy. You need to take a breath, sir. Everybody pause and take a breath. Okay.
Green to raise questions. And again, I said data.
2 years I've not
examiners are
had
just
one.
like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do. And that's what Mr. Green did. So there's great criticism of Mr. Green from doing what is proper for a digital forensic person. And it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's an issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen.
Are y'all hearing me okay over him? Because he's really hot and I can't hear my own voice. So let me know. ADHD, thank you for listening at your job. Have a great day at work and we'll chat when you can. Blessings. Love.
Is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Miss McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports, in that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where the search occurred. Well, that's interesting because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor,
I'd like for them to talk about, I would like for them to talk about the butt dialing and how that was not possible. That was the biggest loss I think I had last year. That trial where he brought up butt dialing, that was funny as shite.
just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
Oh, I have both.
Okay, right, yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both
I
remain
was just going
docketed.
to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks.
How long does it take
In
to butt
terms
dial?
of
How long to butt
The
dial?
allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had two versions of physical analyzer on the market at the same time. One physical analyzer showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYETES. That didn't have it. So Mr. Green did what any good digital forensic person would do. He called up support and said, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing where one party challenges the witness of the other and then says, oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who—
I wouldn't say never.
Well, let me take that back. Good point.
Your Honor, just
It's
let him
so
go.
unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay, any follow-up, Mr. Brennan?
I do.
Okay, I need a breath. I need a little breath. Oh, I need a little breath. Can we all take a little breath? I've never known anyone to talk that fast other than me that would squeeze so much information in and will not take a breath at any point in given time. I don't think I remember him ever taking a breath. And that really bothers me because it is really, really crazy, crazy, crazy how he could talk so long without taking a breath. I'm tired. I'm tired. Dude, you wore my ass out. Oh.
A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffin's opinion that there may have been a connectivity issue is undermined because there was a picture of food, which is
Passionate he is, and
application
that's
search.
what you need.
Misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience.
Oh, yeah.
So there is cache items.
I forgot I do have it on 1.25 speed. But he's still.
That are available without connection that register
Still.
come up quicker from a different source while it's waiting for a search to be conducted. It's simple. It can be explained. It's science. It's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense
Ooh,
apparently
you
is
didn't
mistaken
just
about
say
is using a
that.
number of tools does not substitute for methodology. You can use one tool. You can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to
You
go
just
into
said
the
that.
data
Really?
and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis.
Is that better, ADHD?
And if he doesn't do that, we'll do that for him.
Is that better?
There is no hashtag concern.
I'm having to gain the hell out of this.
Defense raises issues, postures, ideas. We never hear what the problem is. What is the hashtag? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyde next week or even looking at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay, guys, I have this thing so ganged up in my ears and on your end that I have no idea what you can and can't hear. If multiple of you are struggling with the volume, please let me know. If it's only one of us, then crank your volume on your end. I'm not trying to be rude, but I can only crank this so far. And I have actually gained it much more now that I have my soundboard, my ATM Mini Extreme running. So, and I have, unfortunately, the more I gain up the video, I can't hear myself. Well, I really can't hear myself. I can't feel the vibration of me talking in my ears because it's ganged up. So, I'm gonna let my mods, if y'all don't mind, kind of give me some sound corrections if needed.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor.
Okay.
Thank you for the opportunity.
We'll put him on regular speed.
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right.
That's normal.
With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been marked.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep
Yes,
next
thank
week and I'll let you know. All right. So, and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery, and then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along, to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or is in the process of being turned over. There was one further report. We've retained Dr. Wolf as a neurologist. I'm waiting for his report. He is away. So my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I'll have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all discovery.
April Fools. Yeah, let's see if it actually happens on April 1st.
But our discovery should be completed by Wednesday.
Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. It's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right.
The
So,
analysis is done. The accident reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was produced prior. It's all been base numbers. It hadn't been before. It's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those base numbers, and provided everything that I've come across as soon as I come across it.
right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. This went to a protective order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the District Attorney's Office, and that continues, and I have another production as well. So we call it Rule 14.
Matt, do you want Matt?
And I take a very, very liberal and broad view. Of
Sorry.
what I would potentially want if I was defending the case. And I provided that again on the seal today.
All right.
And so we do not have an official discovery order, but I'd like the defense to have the discovery meet 30 days after.
I'm trying to make the caption big enough. Sorry, I'm trying to make the captioning big enough for visually and impaired and the hard of hearing and deaf.
I also, we filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that as an important notice that we had sent in, because I am greatly respecting the April 1st trial date, and there's work to be done. And so I would like to address that motion to clarify what.
There we go.
Okay. All right, I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth.
Woo, this ought to get spicy, y'all. Y'all get
I
ready.
see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition. But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And
Inconsequential?
Ms. Hyde has a report. regarding-
What?
That's all that's really left for discovery. So that's all I can say.
All right. So if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
We've been thinking about it, but we had not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not, the court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it, and we're not.
So
There's no strategy for us waiting. I promise you.
be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly.
I don't know.
Respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation?
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there.
No, what the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
Okay, so
probably
put
a little
it-
bit more accurate for me to just go back and file a supplemental brief.
Yeah, so I need all that information.
Come on,
Potentially
Auntie Bev.
misconduct.
Come on.
Okay, I'll submit that won't take very long at all.
Because then
It is not right for Auntie Bev to be putting this pressure on the defense when the defense is waiting on the prosecution. That's bull crap. I gotta get, I've got to order that. I'm going to be ordering that witch, and it's going to be dangling every time she shows
and
her butt.
we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything in Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. If you are indeed filing a motion to
I'm sorry,
dismiss.
the motion to dismiss on which Monday or Tuesday?
After we meet next week.
Following week.
Yes. I just want to get a schedule.
2
and where we're
weeks,
going, so
my
I need
dear.
Some of these dates. Because
2
we're going to
weeks.
need to schedule a hearing on that. Do not anticipate an evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay.
I'm holding you to it.
We'll be back here at the end of next week. After you have that discovery, I can give you until February 11th, the following Tuesday, to file your motion to dismiss.
That's bull crap. I'm so sorry. That's bull crap.
And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week.
14th, so it'll be heard between the 17th and the
We're also
21st.
going to have to, does the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court can safely
Alright.
say yes.
So February
The 6th.
21st, and I'll put this in writing. Filing of all evidentiary motions, that can be an out of court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
I wish my hair looked as good as hers. I'm just saying.
Your Honor, that week is school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right?
Yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Okay.
I mean, we'll put all our effort into it. If we have a problem, we can let the court know.
Okay.
We'll do our best.
Okay. All right. Okay.
What
so
time?
the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th.
Time?
Filing of all evidentiary motions will be the 21st,
Time?
and that will be an out-of-court date.
Someone get me 11, 14, and
do
21.
the-
Those 3 dates.
Hearing on all evidentiary motions, March 4th and/or 5th. I'd like you to block off both days at this point.
Guys, I'm trying to add.
If we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get ready for trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right. Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe 2, because it was last time on motions in limine. All right, so March 7th will be an in-court date.
Putting the 4th and 5th an in-court date?
And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions eliminated filed by that hearing date, the 7th?
Yes.
I'm trying to get all this. I got the 4th and 5th held. I got the
And then
7th of
on the
March.
18th, which only gives me 2 weeks to decide them.
I'm just throwing these dates up there,
Because we're
saving them as
starting the
them all
trial on
day.
April 1st. Jury Commissioner's Office has been fantastic about getting us as many jurors as possible. And we'll talk about empanelment, obviously, a little bit later.
So right now I have March 4th and 5th as a motion hold date, the
All
7th
right.
and the
Anything else we need
18th.
to discuss today?
Not on behalf of this week, thank you.
thank
Then,
you.
Okay. All right. Thank you all.
then April, March, February, what were those dates? I told you we have the 6th and 7th, the 21st. Karen Reed is a motion hearing that was already scheduled, was a motion hearing on the 18th, 21st. I think that was a out of court filing date. Well, I'll go back and watch those and get those, but I want to know the out of court filing, the filing date, so we know when things drop. So we're done with the Karen Reed. Thank you guys so much for joining. I am, how do I put this? I am kind of shocked, but not really shocked that they are going to be having as many hearings as they are. But I think it's important, and I want to be there for as many of those as possible. Customization, redirect. So we will be redirecting from here in a minute to the Jennifer Crumbly trial, because Jennifer Crumbly's hearing for a motion for a new trial, I understand, was a little bit interesting. So we're going to go do that in just a minute. But first of all, I want to thank all of y'all for being here. I know that you guys are choosing to spend your time with me, and I greatly, greatly appreciate that. We are going to go from the Jennifer Crumbly over to the then we'll live stream the love affair murder trial. So we're going to zoom through. So this is going to help us in a way, because that way we do not have to sit here through lunch with nothing to do. Debbie F. Cook, thank you for joining. I'm sorry I didn't see you hop in. Please don't be offended. But good to see you, my friend. I would love to do a live with you sometime. Just kind of touch base with me. So now what I have to do, and I know it's kind of crazy, y'all, but it is what it is. If anybody was able to get the filing dates in April, I'll have to go back and rewatch it otherwise. So I am going to switch this here, move this here. I've got to go live in one before I can pass on the buck. So this is what we're going to do. First of all, I want to say thank you so much for joining me. I know that there's a lot going on. We had nothing, and now we're overwhelmed with court, which is awesome. I'm happy to be hopping back and forth. If y'all ever want me to do a dual stream with 2 different trials, just let me know. I am capable of doing more than 2. I don't want to. But anyway, let me go live real quick. Y'all hold a second. You guys, thank you guys so much for joining me. I hope y'all have a great day. I'll see you over at Jennifer Crumbly's. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.